Madam Clerk, would you call the next case, please?
State of Tennessee versus David Lyndel Cochran.
Good afternoon, Your Honors. Joshua Hedrick of the Knoxville Bar on behalf of the appellant David Cochran. If I may reserve 2 minutes of my time for rebuttal argument, please.
Certainly.
May it please the Court, David Cochran's convictions for rape and aggravated kidnapping should be reversed for 2 reasons. First, that it was error to permit the nurse to testify as an expert witness, and second, because the evidence in this case was insufficient. I'd like to spend the majority of my time on the testimony of the nurse examiner, and if I don't make it to the sufficiency, I'll intend to just stand on the brief in that regard. In this case, Your Honors, the short version of the case was that David Cochran, the defendant, and the victim in the case were co-workers at a local restaurant. Mr. Cochran worked in the kitchen, and the alleged victim was a hostess, a waitress at the restaurant. And the restaurant closed, and the restaurant owner told everyone, the restaurant is closing, you'll all have no job tomorrow morning, but for tonight, the bar is open, have a party, enjoy yourselves on the house. And everyone was drinking and having a good time. The testimony at trial was unanimous that the alleged victim drank more than I think she should have, and then at some point in the evening, she began to get ill. The other coworkers were helping to take care of her. The restaurant owner had instructed the employees, I don't want anybody drinking too much and driving. If you get to the point where you've drunk too much, I want you to get a hotel room, sleep it off, don't be driving around and get into trouble. And so Mr. Cochran takes the alleged victim, and I'm referring to her in that way because I know these arguments are streamed, and I'm trying to be sensitive about her privacy. I don't want the court to think I'm being minimizing what's happened here. The alleged victim wakes up in the motel room with Mr. Cochran in the room with her. She awakens with her underwear and her brassiere and her clothes all on. She's fully dressed. She is one of them, and forgive me, I forget. One of them is under the covers, and one of them is on top of the covers of the bed. So there, when I was a teenage boy, if we had to share a bed, we would say we sleep over, so as to preserve our dignity. She says that she awakens and doesn't think that there's anything unusual. There's no indication of anything unusual. Her boyfriend is very upset because she did not come home that night and is calling her. She enlists the help of another, the bartender, to suggest that nothing happened. If I call you, say nothing happened. And she goes home to her boyfriend and eventually goes for a sexual assault examination. And then the reports that she was raped. So when it comes to trial, the issue at trial was there consent? Mr. Cochran ends up having a conversation with law enforcement in which he tells law enforcement that he and she did in fact engage in sexual activity. And that comes out at trial, and there's no dispute about that. So the question at trial is, was the sexual activity consensual or non-consensual? That's the question. And the reason why I say that is because eventually I'm going to get back to my argument and talk to you all about whether the testimony of the nurse examiner was properly admitted as an expert opinion. And in order to evaluate whether it's properly admitted as an expert opinion, we first have to know what is the fact at issue to which it is aimed. And that's because Rule 702 requires that for admissibility, an expert opinion be one that, or testimony be such that it substantially assists the jury to determine a fact at issue. And that is intentionally a higher bar than the federal standard for Rule 702, because we know from our Supreme Court in McDaniel versus CSX Transportation, which is Tennessee's Daubert, and that's 955 Southwest 2nd, 257, and what I'm about to quote is specifically from page 265. the additional language, and by that what I mean is the substantially assist the jury, that addition of substantially as opposed to just assist the jury, is designed to encourage trial courts to take a more active role in evaluating the reasonableness of the expert's reliance upon a particular basis for his or her testimony. And so we have really two questions baked into 702. And the first question is, does it substantially assist the jury? And the second question, the second part of the question is, does it substantially assist the jury to determine a fact at issue? Right? So the fact at issue here is, was there consent? So the question is, does this testimony substantially assist the jury in determining whether there was consent? Because if it's not related to a fact at issue, then it fails 702. It has to be something in play, sort of similar to our relevance rules. In this case, there was no determination by the trial court that this opinion of the nurse examiner would substantially assist the trier of fact in determining a fact at issue. The trial court ruled on...
Let me ask you this.
Yes, Your Honor.
One question. And so the victim's in bed with her clothes on, fully dressed, and he's on top of the covers and she's under the covers.
Yes, Your Honor.
Before she left that morning, did he say, it's nice to have sexual relations with you, or did he act like it never occurred?
So my impression from the proof, I don't know that the alleged victim's testimony actually answered that question. And if I'm wrong, I'm happy to be corrected. But my recollection of the proof was that she woke up, realized that she was not in her home, realized next that her boyfriend had been calling and messaging her, and basically said, I've got to get back to my car right now. And he said, okay, I'll take you. And that was the extent of the conversation. That it never got to Your Honor's question, that she basically woke up and said, oh my God, I got to go. And he said, okay, I'll take you. And then they got in the car and drove back to her car. She left. She went home. She had this conversation with the bartender, Morgan, about coming up with a cover story because her boyfriend was very upset and he was moving out and all that.
So as far as the record before us, he never denied a relationship before he told the police that he had a relationship and it was consensual.
That's right. Well, so let me pause.
I wanted to ask, I thought there was a text message where the victim texted him and he first denied anything happening, and then she confronted him again and he said, you know, you wanted it. Isn't that what happened?
She says that she initially told him, and I think this is through the bartender, I might be off, Judge, I'm sorry, but she initially said, you know, if I message you, because what they're talking about is setting up an alibi, right, to a story for the boyfriend, right? If I reach out to you, tell me that nothing happened, right? So then that'll be my proof to the boyfriend. I can show the boyfriend that nothing happened. And so he does that. And then when she presses him, he yields. That's the story that is given to the law enforcement, is that she told me, you know, when I message you, you tell me nothing happened so that I'll have an alibi, right?
How does it go from there to going to be checked out at the hospital?
She?
Yeah, how does it?
Sorry. Right. So what happens is that as I understand it, she goes home and her boyfriend does not believe that nothing happened, and she says that it was not. Maybe I was raped and I don't know, and so then they go for an examination. Is my understanding. I don't know that I have a clear answer for Your Honor on that. I really don't, because she's very clear in her testimony that when she wakes up, she has no reason to think anything has happened. She experiences no soreness, no physical reason to think that anything happened. She says her testimony, and it's at volume 4 at 203. Her testimony, volume 4 at page 203, answers your earlier question, I think, where she's just talking about their discussions when they first awake, and her saying that you need to take me back to my apartment, and then, or my car, not apartment, my car. And then volume 4 at 207 is on cross-examination, excuse me, that's wrong, 216. Volume 4 at 216, she says that she is where she testifies that when she first woke up, she was not sore, she did not think anything had happened, she did not have any physical reason to think anything had happened. And then later on, she develops this a feeling of soreness that basically occurs during the sexual assault exam. But so the difficulty that we have here is that although the trial court ruled on the training, the trial court did not rule on whether this testimony by the nurse examiner would substantially assist the jury in determining a fact at issue.
Why is that not implied in the trial court's ruling? I mean, the trial courts make rulings on evidence questions all the time where you have implied findings. So I could think of, for example, under a 403 analysis, lawyer makes an objection under 403, it's denied. And I think we would say, well, it's implied that the trial court found that the probative value was not outweighed by the danger of unfair prejudice, for example. So why is it not implied in this kind of case?
Well, so I'd like to take the long way to answer your question, and I'm not avoiding it, but I'd like to answer your question, Your Honor, in a way that also addresses the waiver argument. And so the state has raised the specter of waiver. And what I want to do is talk for a little bit, and if you'll bear with me, I think you'll see how it comes back around to your question, that if we look at volume 3 at page 181, defense counsel says that on line 21, I think I've made it clear in chambers that my complaint is only about her attributing injury to consent. That's about the nurse examiner. And then volume 4 at page 288, defense counsel says, in order for the court to act as gatekeeper, we're going to need to establish not just her qualifications, but what the actual conclusions we expect to hear are. And then again, volume 4 at page 255, when the court rules that this is admissible, defense counsel says, well, Judge, my objection from the very beginning has been solely on the question of this injury is caused by sexual assault. I don't object to her outlining what she saw, and then there's some other discussion, but the objection is to the nurse examiner saying that the injury is consistent with penetration, and it's when she says sexual assault that I have a problem. And so then finally at page 256, defense counsel says that the concern is that if we attribute this to being an expert, it gives this extra imprimatur of expertise. And so those are the things that are raised that the trial court does not specifically address. And I know that Judge Greenholz, you're asking, the judge admitted it. Can't we conclude from his admitting it that he has overruled that objection?
Or maybe even more properly, do you have any authority at all that would require the judge in ruling on a 702 objection, 703, that there must be an affirmative finding on the record by the trial court that the opinion testimony would substantially assist the trier of fact? I mean, there's not a case that says that, is there?
There is not a case that says that, but when we consider this from the abuse of discretion standard, when we're applying the abuse of discretion standard to the record that we have, I think that we're in a different position than we ordinarily would be because there are not specific findings from the trial court. That is, there's nothing that we can point to the trial court's reasoning and say this is the standard of law which the trial court applied. Where we run into trouble is the closest the court comes to findings of fact is at page 255, at line 14, where the court, when we're talking about the complaint that the nurse examiner is saying these injuries are sexual assault injuries, the court says, I disagree with you on that because I think she can explain why it's consistent with sexual assault because the person was not properly lubricated and that the mechanism of the blunt force without the lubrication is what causes that injury. We're talking about injuries to the alleged victim. We all know that to be true, so I think it's appropriate for her to say it is consistent with sexual assault. And that line, we all know that to be true, so I think it's appropriate for her to say it's consistent with sexual assault. That is where I suggest that the trial court, that the abuse of discretion standard leads us to a conclusion that the trial court failed in its gatekeeping function. Because the trial court, under McDaniel, or R. Daubert, has a duty to be the gatekeeper and only allow expert testimony if it will substantially assist the trier of fact to determine a fact and issue. If the trial court's conclusion is, we all know this, everybody knows this, then what the trial court is concluding is that it is not an appropriate, it is not a category of expert opinion. It is just general knowledge coming to us with the imprint of the expert. And so it doesn't substantially assist the jury in determining whether there was consent. If the trial court's conclusion is, everybody knows, we all know this, then what that's saying is the jury doesn't require any assistance at all. And therefore, this doesn't substantially assist the trier of fact, and under the gatekeeping function, the conclusion should be, this isn't for an expert to say.
So why isn't this waived?
I couldn't hear.
So why isn't this question waived? As I understand it, it was not raised, the objection, the nature of the objection that you're raising here doesn't appear to be raised in the trial court. I think I understand where you're trying to go with that, but I don't see that it's raised clearly. Certainly the trial court's not issuing a ruling on it. It doesn't appear to be in the motion for new trial. It appears to be raised for the first time here on appeal. So why is this question not waived?
Well,
For plenary
so I have to push back a bit on the court's question, because Your Honor's question, as phrased, is if it doesn't. I would suggest that it was raised, that the arguments of defense counsel as we're going through this, the defense counsel is continually bringing to the court's attention, this doesn't answer the question of consent. I want a ruling on whether this witness answers the question of consent, which, although does not use the magic words of assist the trier of fact, that's the question that's being raised.
Well, but the waiver issue, even if you take that, the waiver issue goes a little further, right? Because wouldn't counsel have had an obligation then to ask the trial court to rule specifically on the objection or risk waiver?
So I think I agree with you. You are correct. I don't disagree with that legal principle. But when we're talking about, when we go through this, the record from the jury out hearing and through maybe from page 181 in volume 3 and then from 255 through 288 in volume 4, I read the record, and I say this respectfully, I read the record as a trial judge ruling on qualifications, and the trial judge keeps saying the qualifications are adequate, and defense counsel keeps saying, yes, judge, but I want you to talk about this question. I'm objecting. Yes, judge, I get it. Qualifications, fine. I'm trying to talk to you, judge, about the conclusion. I'm trying to talk to you about why the conclusion is no good.
Sure. It was
right?
was the argument as to the conclusion, was that raised in the motion for new trial also?
I believe I'm not in a good position to answer that question for you right now,
okay,
Judge.
Fair enough.
I don't want to misspeak. I believe that the motion for new trial simply raises the error in admitting that testimony and is not specific about what type of error there is, but
Sure, but what about in the argument? I mean, was it argued in the motion for new trial? Okay.
And I apologize for not knowing, but I'd have to double check the record. So the trouble that we have here, and the court does rule to a degree As a defense counsel, the last thing that I'll say, as trial counsel, you often have to make those decisions between an area where, when we look at page 255, where the court has ruled and said, we all know this to be true, that's a point at which the argument has been going for some time, and we all have to make a decision as trial counsel of what's that line where you have raised the issue, but you aren't arguing with the trial judge, because there's a point to which there's a difference between preserving your record and arguing with the judge. And I recognize where the court's going with that, but there's always that concern that a defense counsel not cross the line from preserving the record and making the objections to, the judge has said 3 or 4 times, I'm finding this is admissible. There's a point at which you have to stop pushing it. And I think that may come through here. So for those reasons, and I see that I'm starting to cut into my rebuttal time, but for those reasons, and I'd ask that the court allow me to rely on my brief with respect to the sufficiency argument, but I would ask that the court reverse the judgment of the trial court. Thank you, Your Honor.
Mr. Cole?
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments because the proof overwhelmingly established the defendant's guilt, and because the trial court did not err in admitting the testimony of the sexual assault nurse examiner. I do want to cover a little bit of the factual background here. I think there were some facts that need to be highlighted, and I think several of them go to your questions, Judge Holloway. So I think the defendant and I are mostly in agreement, but some things need to be highlighted. So this was a situation where the defendant and the victim in this case worked together at a restaurant. That restaurant was closing for good. And so the final night that it was open, before they shut their doors entirely, once they closed for business, the owner allowed the employees to make free use of the remaining alcohol, not necessarily opening new bottles, but, help yourselves, have a good time. The victim didn't simply just have a little bit more than she should have. She was not simply feeling ill. There was multiple witnesses who testified as to her state. They had to drag her inside. Apparently the employees were sitting out on the balcony or the patio when they were socializing, and they had to sort of drag this victim back inside, lay her down on a booth seat. They provided a bucket because she was becoming physically ill. One individual even described her as blackout. And so she was severely inebriated at that time. And there were several employees who were trying to take care of her, and the defendant at that point volunteered to, and I think it's important here, he didn't volunteer to get her a hotel room. He told the other employees that he was going to take her to her home. And so I think that's important. The other thing, the owner of the restaurant did comment, I don't want people to sort of drink and drive, but did not just say, go get a hotel room somewhere. Pointed out that there was I believe it was a Super 8 motel or some sort of motel right across the street, and said, if you want to get something, go right there. There's a hotel. People can stay there. And the defendant, after telling the other employees that he was going to get this victim to her home, instead drove her to a hotel, and not the hotel right across the street. Drove her several turns underneath an interstate to a hotel that was approximately a mile away. Goes into the hotel front desk, card and license ready, gets a room, and essentially carries her into that bedroom. Now, to Judge Holloway, to your questions, what the interaction that happened that morning, my recollection of the record is that at the time the victim wakes up, she is fully clothed. There is I also don't recall who is under the sheets and who is over, but there is that sort of separation. And at that time, there's no commentary by the defendant as to what had happened. But later on, and I think Judge Wilson, you pointed this out, and this is on pages 205 and 206 of the record. The victim went home, got home, and wasn't just dealing with an upset boyfriend. Noticed that she was starting to feel physically sore, and called the defendant up, or messaged the defendant, and he initially denied ever doing anything. She pushed a little bit harder, and then that's when he admitted it and said, you know what happened, you know you wanted it. So he initially denied it, to your question, Judge Holloway, and then later acknowledged it, saying, you know you wanted it, and then changed his story slightly when he began to talk to the police. And it sort of ultimately evolved into him claiming that the victim didn't just want it, but sort of initiated the contact and really took him by surprise and did everything, took all the actions in this case. So after the defendant tells the victim, you know what happened, you know you wanted it, she determines that she needs to go to the hospital. So I think that was your question, Judge Holloway. Why does she go to the hospital? After she finds out that she has been raped, she just determines that she needs to go and report that. And so I think the defendant accurately points out that really the issue here is whether there was consent, and whether she had the ability to consent as well. But really it's sort of a he said, she said competition. And that's why this nurse's testimony was important and was admissible. So here there was a rather lengthy jury out hearing where the expert testified, and there was a significant amount of discussion. But to your questions, Judge Greenholtz, I looked throughout, and the record, I will rely on the record, but the only part that I could find where the defendant makes a specific objection regarding Rule 702 is on page 252, Volume 4, page 252, and objects to qualifying the nurse as an expert witness, saying, quote, there's not sufficient proof to establish that her methods are accepted in the scientific community, which is a prong of admissibility under 702, under the Daubert-McDaniel standard.
That's an attack on the substantive opinion itself, not how the jury would consider it or otherwise would use it. That sounds to me like that's a substantive attack and different from what is being argued here.
That is my understanding as well, that she does not have, the scientific community doesn't sort of endorse the methodology to support the substantive opinion. My understanding is that argument didn't go at all to whether the jury whether it would substantially assist the jury, whether it would assist them at all, whether it would go to consent, anything like that. It's all about whether this particular nurse and the methodology that she used is sufficient to meet the Daubert-McDaniel standard.
I know he was arguing to the trial judge, but would the defendant have been better off if he had just made a generic 702 objection instead of delineating that ground, that section of the rule? I mean, would that have preserved it? That's my question. I object under 702.
I think maybe under a waiver basis, the defendant's specificity might be damaging to him, but that was how he pursued it, and we don't know how the court would have reacted. If it's sort of an umbrella, I object under 702, the court could say, well, what part? What part don't you think she's established? And we just don't know, because that's not what the defendant chose to do. They specified that it was that her methods were accepted in the scientific community. And so to your question, Judge Greenholtz, of why didn't the judge specifically make a finding on this substantially assisting the jury, it's because the court knew what the objection was. And the court makes a specific finding saying that under McDaniel, I think the science is settled. I think the basis of her opinion is sufficient. And that's on page 254. So it directly addressed the specific portion of 702 that was brought up.
It was the source of the objection. So your waiver notwithstanding, your friend on the other side says, well, the trial court actually made a finding that is counter to what would be needed if the trial court were making a finding that the opinion testimony would substantially assist the jury. And so when the trial court says, hey, look, we all know this to be true, your friend on the other side says, well, that's directly contrary actually to what 702 requires. Assuming that waiver is not at issue, what's the best response to that?
So, and I don't remember that specific quote. I remember the court making some similar comment with regards to the underlying methodology. Okay. So it could have been a comment on the methodology, not whether it would assist the jury. That, I believe, is on page 253. If there is a separate comment, I think the court is sort of thoroughly analyzing its reasoning, or thoroughly explaining its reasoning, and it might have misspoke there, because here it does, the information here substantially assists the jury. And I think that when the court admits it, knowing the rules of 702, the requirements of 702, and specifically focusing on the one portion that the defendant had raised, I think any other commentary isn't necessary. An explicit finding, especially saying we all know what's going on, I don't think that's a finding that, well, this wouldn't substantially assist the trier of fact, which is what the finding would have to be.
All right, so what do we do then? Okay, that's fine. Thank you, John. Yep.
And so after we have that, and I think we've made the waiver argument, but even if this court finds that there's not a waiver, this was properly admitted because the nurse's testimony did go to substantially assist the trier of fact. Again, this was down to a he said, she said arguments, and the victim was saying, I never consented. I talked about how she didn't remember anything from the time she was at the restaurant until she woke up the next morning. And the defendant instead saying, no, she came on to me. She knew she wanted it. It was consensual. And the expert's testimony was that the victim suffered abrasions and these sort of red welts to her private area, and that was consistent with a sexual assault, with evidence of a sexual assault. And that was consistent with a lack of consent. And so I think the defendant mentioned here that there are the two prongs of the substantially assist, that it has to substantially assist and it has to go to an issue of fact that was for the jury. The expert's commentary directly went to sort of the issue that was before the court. These injuries are consistent with a lack of consent and with a forcible rape or with a sexual assault. And then again, it substantially assists because that goes to corroborate and to back up the victim's testimony. So I think the specific prong raised before this court of 702, that it didn't substantially assist the trier of fact with an issue that was, or with a topic that was at issue, has been met. I don't want to belabor the point. This court doesn't have any other questions. The defendant has relied on brief with the sufficiency. I will just comment that the evidence was overwhelming in this case. Unless this court has further questions, we respectfully ask that this court affirm the judgments. Thank you.
All right. Thank you, Mr. Coleman. All right. You have your rebuttal time.
If it pleases the court, I rise primarily because I've had an opportunity to go through the record, and I'd like to answer the question about the motion for new trial. If we look at volume 7, if we look at the technical record, the motion for new trial, which is page 62 in the technical record, merely pleads that it was error to find the testimony to be admissible under McDaniel and Daubert. So, which is not very specific. But then, if we look at volume 7,
and if it was being raised under Daubert, it would not be raising an issue with whether the opinion testimony would substantially assist the jury.
That's right.
Okay.
That's right. And so, I would suggest to the court that. The real claim there is the McDaniel claim, because that's our Tennessee court, right. And there's just sort of the attempt to federalize things. If we look at volume 7, the transcript, which is page 5 of volume 7, that's the transcript of the motion for new trial. Defense counsel is presenting the motion for new trial on this issue. And says that this was a case where we had detailed argument about the red marks, and there was a considerable amount of time on debating whether those were abrasions or not. The court will note from a review of the record that the argument was, what's the basis for this witness saying that the friction abrasions are the result of lack of consent and not just an overeager partner or dehydration by the lady from the result of alcohol. And so defense counsel says our claim was that her opinion was not admissible as it relates to the cause question, and so that what caused the injuries be that caused by lack of consent or simply caused by what I had described at trial in the hearings as an overeager partner who initiated sexual contact before everyone was, say, ready to keep it polite. And so I'd suggest to the court that I think it likely was raised in those ways at the motion for new trial, but there's very little. The motion for new trial was a very brief hearing, Your Honor. And so for those reasons, the last point that I want to make before I sit is that there is a nexus here, that because the argument that I've presented to you today and in my brief is that that the opinion is not admissible, it necessarily involves some argument that there's no method to support the opinion that's given here. And I don't want to overexpand this, but when we think about, the complaint is that a nurse takes a stand and says, this is the type of abrasion that's caused by lack of consent. And the argument is that's not a proper opinion. And there's no scientific method by which you could reach that opinion. For those reasons, we'd ask that the convictions be reversed. Thank you.
All right, thank you. Thank you, counsel. All right, ready to go?
Thank you, yes, sir. Yes.
All right, would you call our final case for today?
State of